I'm the manager of the consumer area in the Auckland office. One of our main roles there is to oversee the credit issues in the CCF Act investigations. So I have a number of investigators there, and we also have investigators in Wellington and Christchurch who carry out some of these investigations. I want to cover off what we've been doing in the past to enforce the law relating to the CCFA, what we found and what we intend to do in the future. In the past 2.5 years, we've been carrying out visits to second and third tier lenders in Auckland, Wellington, Christchurch and Waikato. These visits have primarily been to gain a good understanding of the industry ourselves. We had an emphasis on compliance and in relation mainly to disclosure. The current law, as it stands today, hasn't given us much scope for the behavioural issues within the industry for the conduct. The new law obviously is addressing some of that. Some of you may have been visitors by us in the past. We've actually carried out about 85 visits to second and third tier lenders in those areas that I've mentioned. We commenced a project into truck shops about 12 months ago. The purpose of this was to gain a good understanding of that industry. There's been much said about the truck shops in the media and other forums. A lot of it is hype, so what we wanted to do was to get stuck in and have a look ourselves and really get our own understanding and thoughts around it before we actually started carrying out law enforcement action. So there were a lot of anecdotal issues, but little for us to actually work off. So truck shops really is a bit of a loose term because it encompasses a number of areas, those that operate the trucks door to door and catalogue sales, and also door to door sales where there's no trucks involved, so it might be just someone in a car. Again, one of the main purposes of the visit was to look at contracts and other business processes to ensure that they're conforming with the CCFA and the Fair Trading Act, because now under those acts obviously door-to-door sales and repossession apply. The other area that we've been looking at is gaining intelligence and information, because it's important for the Commerce Commission to work off the best information available so that we can identify emerging issues and also be able to prioritise the issues that we think has or has the potential to cause the most harm to vulnerable consumers. So we'll continue to work with government and non-government organisations, both in New Zealand and worldwide, to ensure we're up to date with trends and emerging issues and what's happening within the credit industry. We were fortunate last year in recruiting Lyall Gibbs. I don't know if many of you have met Lyall, but she is working with us as an advocate in the credit area. Lyall has quite an extensive background in credit and as a budget advisor. The advocacy function within the Commission fulfills our statutory mandate to promote compliance with the laws by providing guidance firstly to consumers so that they know their rights, and also secondly for lenders so that they know and understand their obligations. While our primary role is to promote compliance with the Act through guidance and enforcement action, we understand that there are many barriers around consumers having access to the information we provide about their rights. So the role of the credit advisor was created to increase engagement with stakeholders and in the credit market, with an emphasis on the community and a particular focus on the vulnerable consumers. This approach to community engagement ties in with the new purpose and statement of the Act, which makes consumer protection a clear priority. We are aware there's a reluctance for some vulnerable consumers to approach an organisation like the Commerce Commission and formally lodge complaints. So we rely to a large degree and work with consumer advisory groups to whom these consumers often go to make their complaints or to talk things through with those organisations. It's at this point that issues around non-compliance are likely to be picked up and reported to us. Our engagement with consumer advisors around education and about the law and consumer rights Our message to these groups is to report to us all matters where lenders are not complying with the law. The development of relationships with this sector of the community ties in well with our enforcement approach. We advise consumer groups what we'll be focusing on once the changes take effect. So we have limited resources, and we can't be everywhere. So this approach effectively gives us the eyes and ears on the ground. It raises our awareness and helps us to target our resources where they will be most effective. It's also fair to say that a lot of the information we get about problems within the credit industry actually come from you people yourselves telling us about competitors. So that happens quite often. So what have we found? With the truck shops, this has been a very interesting project. We found that there are approximately 40 truck shop type operations nationwide. A fair concentration of these are in South Auckland, but some firms operate right across the country. We've visited close to 30 of these businesses so far. Generally, we've found that they target the more vulnerable consumers and communities. We've had really up to now quite an educated approach to most informing them of the changes to the Fair Trading Act and the new credit law. Some didn't actually know the difference between lay-by sales and credit contracts. We encourage owners to seek advice to ensure their contracts were compliant with working under the lay-bys and credit areas, or both. We also gave them advice to check whether they needed to be registered under the FSPR. We've identified some serious breaches of the CFA with one company. We have a further 5 companies under review and have issued compliance advice to others. The main issues we have identified have been mainly disclosure issues under the CCCFA and Fair Trading Act issues relating to uninvited direct sales. Some of the issues identified have been highly inflated prices, which we've obviously got no control over. The quality of goods hasn't been what was expected by the consumers. The goods are often poorly described, and often the prices were set as weekly amounts, and therefore the buyer did not know the total cost of the goods. Some also had buyers fill out multiple direct debit forms, so if one is cancelled, another can be activated. So the second and third tier lender visits, and generally we found that there was compliance with disclosure. We did find, however, that there were a number of outliers. In one case, the lender was still working under the Credit Contracts Act 1981, therefore the disclosure was absolutely deficient, and it was recent. We also did work within the Pacifica lending area, and really a lot of that is concentrated in the South Auckland area. There's what is described when we've been to forums down in South Auckland that there's a real black market in the lending area, and it would be fair to say that people in that black market area aren't sitting here today. It's quite an underground, and we're trying to actually get information and intelligence on that so that we can actually work within it. Because it is one of the areas that we think that there's a fair bit of the harm to the vulnerable consumer in that area. We found that some lenders were working from home. They'd never even heard of the CCCFA. One house I personally went to, they were working off an exercise book. They had a number of, they'd taken a whole heap of EFTPOS cards off people, including the PIN numbers, and they were going each week to the bank and withdrawing the money to service the loans from those people. So look, it would be fair to say that again that's not common, but we know that it does go on, and we will actually be taking strong action when we do find that type of activity. We have current charges laid against a Chinese lender who was working in the Auckland casino area and in dark corners of the car park, bundles of cash, and we know that there were serious threats against people who didn't pay back the loans. We've also current charges against another payday lender who again is also on police charges in relation to carrying offensive weapons. So I'd suggest that if you're going out to collect debts, not take a machete with you, or else the police might have to get involved alongside us. When we worked through the issues that arose with lenders, we did find that most of the issues were around disclosure of fees, which probably isn't a surprise to me. Really, we think there's no excuse for getting disclosure wrong, especially if people have got a good computer system, and work with a good computer system, or they have sought really good legal advice. So much of our work in this second and third tier lender area have been educative. We therefore reviewed the contracts from all of the lenders visited, and when necessary, we've given compliance advice around those contracts. So what are we going to do? Firstly, the responsible lending principles. They focus on lender behaviour in a range of situations. We'll be focusing on issues that we can take immediate action on. One of these is advertising, as Yvette's been explaining to you. The principles require that the advertising must not be misleading, deceptive or confusing. And I think it's important to emphasise those words again to you. Lenders must also exercise care, diligence and skill when advertising. So as soon as the principles come law, and on the 6th of June, we'll commence a project focusing on credit advertising. We'll be reviewing truck shop catalogues and lender websites. We are already reviewing local newspapers and websites, computer advertising, listening to radio jingles, noting billboards, etc. We already have complaints about some lenders offering credit where, as someone described before, they're saying no cheques will be made, loans guaranteed, no questions asked, etc., etc. We'll be visiting lenders, and lenders, so we'll be focusing on lenders' inquiries and checks. So lenders must make reasonable inquiries that the credit will meet the borrower's needs and that the borrower has the ability to repay the credit without substantial hardship. Again, you've heard these words this morning. Please note them because they're the important issues that we'll be focusing on. So we'll be focusing on payday lenders and truck shop catalogue sellers in the first instance. We think the issues in this area will become evident quite quickly. This is because the loans are short-term and are often targeted at the more vulnerable consumers. To do this, we'll visit payday lenders and truck shop operations to actively investigate whether they have programs or processes in place to make the appropriate inquiries to meet the principles. We will expect lenders to show in their process the steps they go to with the borrower, and also they will have available evidence to show that they've carried out the pre-loan checks diligently. We will work with budget advisors to identify lenders who are problematic. We will carefully assess all complaints we receive to see whether there was non-compliance with the principles. We will also be assessing all credit contracts we see for unfair contract terms. So lenders who follow the Act and have proper regard to the code and the interests of consumers should require our attention. And that will enable us to focus our resources on the more unscrupulous lenders who cause significant harm in the vulnerable consumers, to the communities. In relation to unfair contract terms, the Fair Trading Act has empowered us to enforce unfair contract terms. And unfair contract terms apply to standard form consumer contracts entered into on or after the 17th of March 2015. or existing standard form contracts that are varied after that date. This does not apply to insurance contracts. Repayment waivers, however, will fall under the unfair contract terms provisions. We will be examining waiver documents for unfair contract terms when we review credit contracts. A common clause that we see in waivers is that claims may not be made if the borrower is in default at the time of the claim. This is the type of term that could be considered unfair. And if the lenders include this clause in their waivers, we may require lenders to justify that this is necessary to protect their legitimate business interests. Another term that could be considered unfair is the time period for making the claim, which is tied to the repayment schedule, which can be very short, obviously. This means borrowers may only have a very small window to make a claim. So if, for instance, the repayment period is 2 weeks, if customers don't know about the time limit conditions, then they may not make a claim in the time required. The way we'll approach these issues is to require you to justify the term. If we believe the term is unjustified, we will consider taking court action, seeking a declaration from the court about it. Repossession, you heard a lot about that from Susan. So our work in this area will be complaint driven. We intend to vigorously prioritise complaints received, mainly because of the harm it can cause to vulnerable consumers if the practices are illegal or oppressive. We'll be working with the Department of Internal Affairs where breaches of licences are detected. Standing disclosure. We propose conducting a review of lender websites and other forms of advertising to ensure that standing disclosure is made. This work will be undertaken at the time that we are looking at the lender websites and other media channels in relation to the advertising as mentioned earlier. We'll also be acting on any complaints received in relation to standing disclosure. We will focus on classes of contract. Lenders will need to show the range of interest for each class of contract. We will expect that lenders will be able to prove that they have lent money in the lower end of the range. If borrowers haven't been able to borrow at the lower rates in your range, then we may need to consider whether the range is misleading and therefore a breach of the Fair Trading Act. Fees has been mentioned also earlier, but we certainly will be investigating fees. We'll be using the Court of Appeal judgment, the MTF Sports Zone, as our guide. The guide that was advertised or is in the Commission website is not the guide that you should be using. You should be using the MTF Sports Zone guide. We will continue to review all consumer credit contracts we view through investigations or complaints that we receive. And we'll be looking for high fees. We'll also consider fees when we conduct our review of lenders' standing disclosure on websites and other media, as lenders need to disclose fees. What is key is that fees must have a close connection with the costs incurred. Truck shops. By June the 6th, we consider that truck shop and catalogue sellers will have been given ample advice about the changes to both the CCCFA and the Fair Trading Act. We will therefore be reviewing truck shop catalogues and advertising, as some of our key concerns in the credit area has been about these traders. We will have the power to issue infringement notices, as previously mentioned, for disclosure breaches, and we'll use this power if we think it's the appropriate one to use other than prosecution or appropriate response, and maybe other forms of response that we use as well. So the expectations that we have is we expect that lenders, truck shop owners, catalogue sellers will be in a position to be compliant with the new changes to the law when they come into effect on June the 6th. The assent date for the changes was on June the 6th, 2014, so there's been a 12-month lead-in time where these changes to the law have been quite clear in the amendment. although the responsible lending code's only come out 2 or 3 months ago, it's the principles that we can enforce, not the code itself. So that's been previously mentioned as well. So our expectation is that you'll be up and running by the 6th of June with the changes that you might have to make to comply with the law. So in the last year, we've really been working to prepare lenders for these changes. We've had a number of forums. We've got forums such as this. There is our website has guidance on it, and the overview fact sheet that you've been handed today is the overview of those changes. So the Commission does have enforcement response guidelines. That's what we work off when we're making decisions around what we do with, to enforce the law. These are also, if you haven't seen them, they're published on our website. They're quite clear. We always take into account the enforcement response guidelines, as well as other contributing factors when making decisions on our enforcement approach relating to the breaches of the law. So I'd really emphasise that you do have a look at those. Have a look at your systems and processes. You can expect that probably in the next while there may be a visit from us to talk to you about the processes that you've got in place. And that's about it from me. Thank you very much.